Hello, everyone. Welcome to the Sentencing Project's webinar today. Thank you for joining us. My name is Jean Chung. I'm the Communications Manager at the Sentencing Project. And our webinar today is on current efforts to reform state policy on sentencing and collateral consequences. Our presenters will highlight state activity in Delaware to scale back the state's three strikes law, a recent victory in Georgia modifying the lifetime ban on food assistance for persons with felony drug convictions, and Michigan efforts to address sentencing policy for violent offenses. The webinar slides, as well as a recording of the webinar, will be available online, and we will send the links to access those after the webinar. There will also be a Q&A session after all of the presenters have spoken, and you can actually submit your questions throughout the webinar using the questions panel on the webinar screen. So our first speaker today will be Fennell, a policy advisor to Delaware Governor Jack Markell and former executive director of the Delaware Criminal Justice Council. She served for a decade as executive director of the American Civil Liberties Union of Delaware and was an attorney with Young, Conaway, Stargatt, and Taylor LLP. She has a University of Delaware undergraduate degree and a law degree with honors from Rutgers University, where she served on the Rutgers Law Journal. She serves on the Delaware Sentencing Accountability Commission and on the boards of various community organizations. Her work has earned awards from the Delaware Human Relations Commission and other institutions. With that, I'll give it over to Drew.
Thank you very much. It's a pleasure to be here with you. So it's an unusual career path that takes me from being a corporate attorney through the ACLU and then now being the policy director for the governor of Delaware, Jack Markell. And I want to talk to you a little bit about some of the sentencing reform work we've done here in Delaware. It's really part and parcel of a much larger criminal justice agenda that I've been very fortunate to have a governor who was really willing, back in 2007 when he was running, to really put this front and center in his campaign to talk about things that were uncomfortable, and most of you on the phone were probably working on this area as well at that time. It was an unusual conversation for a politician in a tight race to be having in 2007 and 2008, and that's what we had here. But what we saw and what he recognized was the tremendous toll that reentering inmates had on their own lives from their incarceration, and also the toll that having so many people in the community being in prison and returning to prison without proper reentry supports was really problematic. So we began that work as soon as he came into office, and we've done a lot since. We were a Justice Reinvestment state. We passed a Justice Reinvestment Act during his second term in 2012, which reformed a lot of things inside our Department of Corrections. One of the things that sort of led, and I give that as background to talking about an habitual offender statute, or three strikes as some states call it, because it was really important to lay the groundwork in the system, judges, deputy attorneys general, politicians, legislators, people in the community, so that they understood sort of what our prison and jail population look like. So Delaware is a little unusual. We have a unified system. So we have a single attorney general whose jurisdiction is statewide. We have a single Department of Correction whose jurisdiction is also statewide. So all of the things that we've done here affected both our jail population and our prison population, which means we've done actually, for a state, quite a bit of work in areas that most states don't do, like pretrial detention. But as we learned and we sort of began to educate our community more and more about who was actually sitting in custody with us, we found some surprising things. One was that we had 22% of our daily population, somewhere between 22 and 26, depending on the time of day, were pretrial detainees. We also identified that we had a very large, long average sentence, and we realized that some of this was being driven by our three strikes law. So beginning a couple of years ago, we began to have a conversation with legislators and others about how to change that law. Delaware's law is not like other people's laws in some ways. I won't go bore you with all of the details. It is somewhat more flexible than the automatic three strikes bills that some states have. But it is entirely at the discretion of the Attorney General. So whether or not someone is deemed an habitual criminal is entirely up to a decision by an Attorney General, Deputy Attorney General, to file a petition with the court. And the court has no discretion to deny that petition. And what it does is it plants a very, very steep minimum mandatory sentence. And so one of the things we did was there was a section of the code that we have repealed, which actually allowed a mandatory life sentence for drug crimes, for certain higher-end drug crimes, but nevertheless, drug crimes and life sentences likely do not belong in the same paragraph. So we're doing away with that entirely, and then we are restructuring the minimum mandatory portion of our law to bring it down a little bit. We were not able to persuade others around the table to eliminate the habitual criminal statute altogether, but we've been able to make some important changes in how it's applied and the places to which it's applied. So now only violent offenses will trigger the mandatory minimums. So that's an improvement. It's not everywhere we want to be, but it's a big improvement. Later in the program, we'll distribute a little bit of political theater to you, a couple of op-eds, one by the primary opponent and one by our governor and our attorney general together about why the bill was important. So I won't go into all of that. I know you want to talk a little bit about the politics. The politics here have been very, very contentious. Although we got, we are through the House, or through the Senate rather, and we are in the House, and I expect that we will pass and sign the bill. But it does not mean it's been an easy battle, and as I said earlier, it's been a couple of years in the making, really educating people about who people are, what it means, what it really means in a very tangible way to impose a life sentence on someone, and what happens as in the system as that person ages. And so we're beginning to get, I think, a more humanizing approach to looking at individual offenders. I mean, this is the ultimate in sort of broad strokes application of sentencing law. It doesn't provide any discretion to anyone once it's triggered. And so, including you're not allowed to seek any kind of relief from it once imprisoned. So what we've done here is really to work with everyone around the table to understand where we are, to try to humanize the people who are involved, and to make sure that we had at least some members of law enforcement, in this case our Attorney General's office, that were in our corner to help sort of push forward what they think and believe is both a good public safety policy but also good public policy. And I think that we've really succeeded in that, and I think that we will see in the next few years, if we're fortunate enough to get this through the House, I think we will see some movement in future years. I had a question here. Would you like me to address that now, or would you like me to address that at the Q&A time?
I think you can wait until the Q&A to address that.
That sounds fine. So I'll just close by saying that we've made a lot of progress in Delaware in these areas, ban the box. We've restored driver's licenses. We used to take driver's licenses away from felons. We are working on a felon voting bill that will further liberalize our voter registration rules. There are about a dozen different areas in which we've managed to make statutory changes, most of them in the last 3.5 years. So it's been really a brisk pace, but like lots and lots of these things, it was a long slog up a very steep hill to get to a point where the ball would roll. So, that's my biggest comment about the political process is, patience is a virtue, and, what I tell the young people who work for me is that, be patient in the long term and urgent in the moment. Never let one of those moments go past you, but understand that the big changes that we all seek can take lots and lots of those urgent moments to accomplish. So.
Wonderful. Thank you, Drew. Our next presenter is Elizabeth Appley, who is an Atlanta attorney involved in arbitration, mediation, litigation, and lobbying at the state and federal levels in the executive, judicial, and legislative branches of government. Elizabeth represented the Central Outreach and Advocacy Center, who anchored the campaign to expand food assistance to persons with felony drug convictions. Elizabeth has secured numerous legislative successes at the Georgia General Assembly and won groundbreaking cases in the areas of health law, education law, employment discrimination, constitutional rights, and rights of people with disabilities. Elizabeth is a graduate of Hampshire College in Amherst, Massachusetts, and Columbia University School of Law, and a past president of the Georgia Association for Women Lawyers, as well as having served on numerous national, state, and community boards. Elizabeth, you can take it away.
Thank you. Good afternoon. It's a great pleasure to be a part of this webinar and to speak with you about the issue of lifting the lifetime ban on the receipt of food stamps by people who have committed drug felonies. It's ironic, or coincidental, I should say, that the front page of the Atlanta Journal-Constitution today has a story from the Associated Press, and the headline is "More States Are Ending Food Stamp Bans." Well, the story has a small box noting that Georgia has acted by passing legislation to do that this session, but the story is all about what's happening in Nebraska. And in fact, in Nebraska, despite the passage of this legislation by a majority of the legislature, through some procedural maneuvering, that piece was deleted. Advocates are working to bring that back. The story goes through the arguments on both sides and the political tensions that surround this issue. Next slide, please. So what I'm going to talk to you about briefly is what advocacy tools we use to prevail here in Georgia. As you may know, in 1996, federal law was passed to prevent the states from providing food stamps to people with drug convictions, with felony drug convictions, but it did give the states an opportunity to opt out. The majority of states have taken that opportunity, and there's only a handful of states, 6 or 7 or 8, depending on who's counting, that have a full ban still left in place. Most states have modified the lifetime ban on the receipt of food stamps or SNAP benefits, and a few have actually acted to fully lift the ban. Last year, Alabama and Texas changed their laws, and that made the lift here in Georgia easier. The case that we made, and I'm sure the case that has been made across the country, is that access to food stamps is a meaningful way to help people leaving prison to succeed in their efforts at reentering the community and securing employment, rejoining their family, and normalizing their lives and avoiding recidivism. We also documented and highlighted the fact that the denial of food stamps hurts the ability of people to reunite with their families because it makes less food available for more people. Finally, we argued that the denial of food stamp bans applying only to felons with a drug conviction made no sense. No other criminal offenses are affected, and the research shows that this law had no deterrent effect. Finally, we're able to point to the fact, which seems to need repeating, that food stamps are fully federally funded. States share only in the cost of administration, which makes it particularly foolish for states to impose onerous eligibility requirements and sanctions, because this is where the state dollars come into play. Next slide, please. And so Georgia is very fortunate. We have a governor who has led on the issue of criminal justice reform. So we have a Republican governor, Republican control of both the House and the Senate by at or near a 2/3 majority, and yet the governor has acted in a way that has secured very broad bipartisan support on the issue of criminal justice reform, of which this lifting of the felony drug food stamp ban is only a small part. But the problem, and the problem that was highlighted in this news story about Nebraska, is that the legislature here and in other places has taken really a very punitive approach in addressing the issue of food stamps, focusing on limiting eligibility, imposing obstacles to access, addressing fraud, and not looking at the issue of hunger and how it impacts the community. So we brought together a coalition, the Central Outreach and Advocacy Center, which provides services to homeless and near homeless people in order to help them avoid or recover from homelessness. Presbyterians for a Better Georgia, a coalition of congregations working on social justice issues. The Georgia Justice Project, which is an organization focused on criminal justice reform. The Georgia Budget and Policy Institute, which is our local state financial SFAI, our Financial Analysis Institute, and Voices for Georgia's Children, which advocates on a broad range of children's issues. Next slide, please. And so together, we worked with the Criminal Justice Reform Council that Governor Deal established in order to work year after year on this issue of criminal justice reform. We relied in the first instance on a very fact-based analysis that Georgia Budget and Policy Institute put together for us that was Georgia-specific. Over the past 5 years, they showed that over 10,000 people a year were being released from state custody with drug felony offenses, and that 2/3 of those people had children. We showed that the effect of denying these benefits was to make it harder to reunite with families, harder to restore folks to the community in strong ways. We demonstrated that over 550 Georgians each month were being denied food stamps because of a drug felony, and that didn't even begin to include all of those who didn't even apply because of the ban. And we showed that almost 2,000 children were going to be affected by the denial. We were able to show that the state was foregoing over $10 million a year in SNAP benefits to Georgians, which when you add the economic activity of each one of those food stamp dollars would mean $17.7 million in economic activity lost to the state. So it made no sense. Even so, we showed that the number of applicants, while large, that would be affected by the lifting of the ban, still only amounted to fewer than 1% of Georgians receiving food stamps, and so the state's piece relating to the cost of administration would not be affected. Next slide, please. Well, the Criminal Justice Reform Council had made kind of weak recommendations in past years relating to the food stamp ban, but they'd always addressed it as a modification rather than a full lift, and they talked about it in the context of a massive overhaul of the food stamp and TANF program, and it never went anywhere. We had a strong commitment to include this piece in the governor's legislation, only to find a day before the bill was to be introduced that the language would not be included because some of the news coverage on the council's recent recommendations highlighted this issue and received some pushback from some legislators. So we had to really go to work there, working with the leadership of the council, with legislators, and with the governor's office to find a way forward, even in this toxic political environment that was hostile to the idea. Finally, we were able to negotiate, with the governor's permission, an amendment to the bill that happened. It was a Senate bill, and the amendment happened on the House side. It wasn't the full lift that we hoped for, but it tracked the Texas and the Alabama approach of allowing people eligible for food stamps once they left prison, and if they were in compliance with the conditions of their probation or parole, to receive benefits. If they violated their probation or parole in the future, that would mean a loss of eligibility. And so the legislation was not all we hoped for, but it puts us substantially on the road to helping most of the people affected. Since this is a part of the governor's package, we do anticipate that he will be signing it on or before May 3rd, when that 40-day window for him to sign or veto legislation ends. And I appreciate your interest in the issue and look forward to your questions.
Thank you, Elizabeth. Our next speaker is Ronald Simpson Bay. During his 27 years in a Michigan prison, Ron earned a reputation as a staunch advocate, promoter, and defender of prisoner rights. Ron continues his commitment to activism in his work as the Alumni Associate for JustLeadershipUSA and in his former position with American Friends Service Committee's Michigan Criminal Justice Program, where he established a prisoner co-mentorship program, the Good Neighbor Project, the only one of its kind in the state. With that, I'll give it over to Ron.
Thank you. Thank you for having me, and thanks for putting together such a remarkable webinar and allowing me to be a participant in it. I would like to touch on the topic of presumptive parole here in Michigan. We have a bill pending in the House called 4138 dealing with presumptive parole, and let me give a little bit background history on that. In Michigan, we have what's called an indeterminate sentencing scheme, and what that means is that the court sets the minimum sentence after trial, after your conviction, and the maximum is established by statutory provisions, by the law. So when you get convicted and sentenced in Michigan, you receive a minimum from the court, and the maximum is set by statute. But what has happened in Michigan is that in 1992 we had a whole overhaul of our parole system. They established some parole guidelines. And so what happened for the last 20-something years, much of the growth in Michigan's prison system has been caused by a decline in parole granting rates. Thousands of prisoners with good institutional records who have served their minimum sentence are being routinely denied parole. The statute has always said that prisoners being considered for parole and who have a low risk score assessment should be released unless there are substantial and compelling reasons by the parole board. However, the parole board are totally ignoring those substantial and compelling reasons, and the bill would mandate that parole be given to prisoners who have served their minimum sentences unless the parole board can discriminate or demonstrate the prisoner poses a threat upon release. And presumptive parole, it's not a radical experiment. It's a means for looking at how the state enforces its existing policy. Think of it as accountability 101. Once an offender has served a minimum sentence as prescribed by the judge, then why shouldn't the parole board explain to the court and to the prisoners why they should not be released? So this bill under presumptive parole seeks to compel the parole board to do just that. Now there's a number of pros and cons dealing with that issue, and it's funny because in Michigan you have an attorney general who is pretty much hell-bent on not granting any type of relief under any circumstances. I mean, no matter what. So one of the questions always is what is the problem that this bill intends to fix? And we seek to fix the inadequate compliance with the existing parole guidelines. The parole board has defined substantial and compelling reasons very loosely, really too loosely. It often appears that they are denying release to lower-level offenders based on the reactions of some of the board members because of the crime. We know that the factors of the crime will never change, but the behavior of the person who committed the crime from the time they committed it to 15, 20, 30 years later afterward is what should be considered. So we seek that by punishing people longer than their sentence, then the judge intended them to be sentenced. The board is actively engaged in the resentencing. And we feel that that's a very, very harmful practice. And only thing it does is to increase our prison population unnecessarily. We're always talking about in Michigan how bad the roads are, how bad the school is, the current water crisis in Flint. Money that's being diverted from these areas is being pumped into the prison system and could be reasonably put back out into the community. The CAPS, it's an organization called CAPS, Citizens Alliance for Prison and Public Spending. And they have come up with a brilliant worksheet that talks about how much cost could be saved if we actually release these people at their minimum out dates if they don't have any infractions. And we could save in Michigan a total of about $162 million a year from the budget. They could go back into our community, they could go back into the road system, could go back into the infrastructure that could be saved just by releasing people up on their minimum sentences. So that's kind of the lay of the land here in Michigan. There's a situation with medical parole. We know that the elderly prisoner population here in Michigan is expanding exponentially, and the cost for incarcerating them increases each and every year. Currently, the average cost of incarcerating a healthy person in Michigan is around $35,000. But when you get the elderly population, 55 and over, especially with those with medical issues, it goes over $100,000 pretty easily. Now, another bill we seek to pass is the judicial veto bill. And what that means in Michigan, people serving life sentences have to go before the sentencing judge to get a public hearing. The parole board looks at the case and they decide whether they want to parole this person. And if they do, they make a motion to the court, a letter to the court saying we would like to have this person considered for parole. We're going to put them forth for what's called a public hearing. However, a lot of times by the time a person has served 30, 40 years, the sentencing judge has retired or died and his successors, 2 or 3 successors removed. And all that person has to do is say, I have no interest in this person getting a public hearing, and the process stops at that point. The successor judge has no particular connection to the case other than reading the file, and 30 years later he can say that, well, this case should not go forward. And all we want to do is remove that impediment from at least having a person fairly considered for parole. And lastly, we have an organization called the Collaboration to End Mass Incarceration in Michigan. It's a collection of about 22 or 3 of the top advocacy organizations in the state. The American Friends Service Committee, ACLU, CAPS, Michigan United, and others. We have come together under one umbrella to try to seek some responsible policy change, some responsible change within the operation of the prison system, and some community activism so we can end this mass incarceration problem here in Michigan. And with that, I'll yield until we get to the Q&A session.
Thank you, Ron. We actually have one more presenter before we get to the Q&A, and that's Nicole Porter, the Sentencing Project Director of Advocacy. She manages the Sentencing Project's state and local advocacy efforts on sentencing reform, voting rights, and eliminating racial disparities in the criminal justice system. Her advocacy has supported criminal justice reforms in several states, including Kentucky, Missouri, and California. Porter was named a new civil rights leader by Essence Magazine in November 2014 for her work to eliminate mass incarceration. And with that, I'll give it over to Nicole.
Thank you, Jean, and thank you to the other panelists for participating this afternoon. I want to offer a few highlights from other states working on efforts to challenge mass incarceration. In order to scale back the rate of incarceration, each state will need to have meaningful efforts that include formally incarcerated persons, elected officials, policy advocates, the faith community, grassroots organizers, and others. I just want to offer a few examples of activity that we are aware of, and perhaps in the Q&A, there will be an opportunity to hear what other states are doing too. On sentencing reform, including revisiting mandatory minimum policies and other known drivers of mass incarceration like habitual offender laws, there is a range of activity among states. In California, there is current legislation called Repeal Inactive Sentencing Enhancements that repeals a section of the code that adds additional years of punishment for a prior nonviolent drug offense. Most state criminal codes are complex with overlapping criminal code violations that enhance a prison term by lengthening the sentence. This measure would repeal one of California's sentencing enhancements. This legislation is anchored by several state groups, including Californians United for a Responsible Budget, the Drug Policy Alliance, and the Ella Baker Center for Human Rights. Also, with regards to state sentencing reform, there's current legislation in South Carolina that will be heard in committee this Thursday to scale back that state's mandatory minimum prison requirement for no parole offenses from an 85% time served minimum requirement to a 65% time served minimum requirement. That legislation is anchored by a grassroots coalition of activists, including family members and directly impacted persons. These activists were in part motivated by a recent law change in Mississippi that scaled back that state's mandatory minimum requirement for certain violent offenses from 85% time served to 50% time served. In recent weeks, comprehensive reforms have also passed or moved in other states under the Justice Reinvestment Initiative, states like Alaska and Maryland. Other activities so far this year includes efforts to challenge racial disparity. In New Jersey, there is current legislation in the Assembly and the Senate to require racial impact statements for proposed sentencing laws. Like fiscal and environmental impact statements, racial impact statements assist legislators in detecting unforeseen policy ramifications like the sentencing disparity between crack and powder cocaine. New Jersey's effort has garnered support from a coalition of black ministers. And other states that have introduced similar legislation this year include Wisconsin and Washington State. There's also been a range of activity on collateral consequences. As many of you know, it remains incredibly important to address the barriers that can impact a justice-involved person long after their criminal sentence. There's a range of collateral consequences, including automatic loss of voting rights to automatic bans on housing. Earlier this month, the Department of Housing and Urban Development, the Federal Department of Housing and Urban Development, issued new guidance to landlords and home sellers that turning down tenants or buyers based on their criminal records may violate the Fair Housing Act due to systemic racial disparities of the American criminal justice system. Just today, legislation was introduced in the District of Columbia to codify this guidance for fair chance housing into law. Other state activity on collateral consequences includes activity in Kentucky, where that state's Republican governor recently signed legislation expanding expungement provisions to the state's lowest level of felony classification for certain offenses. Persons with qualifying felony convictions are now eligible to petition for an expungement 5 years after they completed their sentence. Previously, expungement was only available to persons with misdemeanor records. In Maryland, earlier this year, a grassroots coalition anchored an effort to automatically restore voting rights to persons living in the community under felony probation or parole. About 40,000 individuals have their voting rights restored and are eligible to vote in the state's upcoming election. Also, there's been additional movement on fair chance employment. Similar to fair chance housing mentioned earlier, much of the activism has focused on addressing employment barriers for persons with criminal records, otherwise known as ban the box. Recently, Missouri's Democratic Governor Jay Nixon issued an executive order establishing a fair chance hiring policy for state employment. The governor moved following a coordinated public education campaign of that state's Second Chance Coalition that included the state group Empower Missouri in collaboration with activists who had prior justice involvement and were directly impacted. Also this year, Oklahoma's Republican Governor Mary Fallin also issued an executive order establishing a similar policy. This overview is by no means to provide a comprehensive list of all of the activity. I invite callers to get in touch with us to share their stories of advocacy and reform in the effort to challenge mass incarceration. And with that, I'll turn it back over to Jane for the rest of the call.
Thank you, Nicole. And thank you to all of the presenters. At this time, we will open it up for Q&A. Again, we invite you to send in any questions that you have for any of the presenters using the questions panel on your webinar screen. And if you're sending in questions now, please do note if your question is for a specific presenter so that we know who to field it to. For now, we'll start with a question for Drew that's about Delaware. The question says, I understand that Delaware has 5 levels of accountability from unsupervised probation to incarceration, level 1 to level 5. Has this enabled more nuanced and targeted sentencing for offenders? Are there enough mid-level options for offenders? And has this driven up costs by requiring more options to be created or saved dollars by providing less expensive options than prison? And presenters, please do remember to unmute before you answer a question.
Hi, thanks. That's actually a really great question, and it highlights, I think, the sort of the history of how this problem has been approached. Right? How do we do just sentencing that really works? So our Sentencing Commission actually put in place the 5 levels of accountability in the 80s. And it was in response to a movement then around the country. It sounds like Ronald was spared that in his state, to move away from indeterminate sentencing and toward what they call truth in sentencing. So life means natural life, 10 years means 10 years, there's no getting out early, it's very, very tough. And so it was a response really from the courts to say, okay, fine, but we want to continue to have some discretion to shape individual sentences in ways that we think are effective. So 5 and 4, 5 is what we think of as prison, full-on incarceration. 4 is supervised custody, so that would be, think, a work release facility or a supervised halfway house. Levels 3, 2, and 1 are probation out in the community with descending levels of supervision. So level 3, you might have as much as nightly curfew check, down to 1 where you're not going to encounter a probation officer unless you get arrested. And obviously the vast majority of our folks are on level 1 probation. But what we found is that it focused so much on Department of Correction activity and supervision that it wasn't really responding well to the sort of what you characterize as sort of the mid-level people. So one of the things that we've done is to try to use what we already have in place to fold in what we're doing now, which is a risk and needs assessment of people as they come through. So we're using a number of tools to try to identify and basically get the courts and the attorneys general and others comfortable with the idea that we should be basing some of our sentencing decision on what the risks and needs of that individual actually are, including, risk of just plain old rearrest and reoffense for a low-level crime up to sort of dangerousness and other kinds of issues. And I think this really has come out of a real partnership between the courts and the executive branch, and understanding that it was very difficult to sentence people to something that was meaningful and helpful. I don't have to tell you guys how large a number of people that are incarcerated here as elsewhere suffer from mental illness or have substance use disorders or both. And so there simply wasn't enough treatment. When this began, now nearly 30 years ago, it was part of its goal was to provide those kinds of services. It was never fully implemented. So I'm hopeful that as we are moving through this process, we're going to get more and more of a handle on who we should be keeping in custody and who we should not. I said earlier in my remarks that we had 22% of our population were our pretrial detainees. That's, it's actually a little less than that now. The high was 26% when we started. It's at now a little bit lower than 22%. But it's really because of really a failure of this 3-2-1 system to provide enough comfort for judges and law enforcement and others that there would be some kind of treatment or safety plan for people that when they went back to the community. And so I think we're succeeding, at least in the pretrial area, in figuring out how to do alternatives to treat pretrial detention for mid-level and low-level people in custody. So in our sentenced population, I think we are beginning to work right now with the court in doing a couple of things, cleaning up our criminal code, which, as someone alluded to earlier, I think it was Nicole, has a lot of overlapping charges and statutes, and trying to get that in control. As always, the biggest issue is resources. Building programs that are useful and usable. I mean, you hit the nail on the head. It can be expensive, and it's hard to show the savings, especially as you're beginning a project, because criminal justice systems by very definition can't sort of shut down one thing today and start up new tomorrow, because there's a lot of historical stuff that has to be dealt with in any given person's way of being. So even case management systems sort of struggle with record keeping and all kinds of things. So trying to stand up a new way to do it while you maintain the old way of doing it is costly. But we've got people here who have been willing to make those investments, and I think we're going to be able to use this structure in the way it was intended, and I'm looking forward to being part of that in the coming years.
Great, thank you, Drew. A couple people had the same question for Elizabeth, which is, what are the states that continue to have the full ban on food stamps?
That's a good question. And so my best answer is Alaska, Arizona, Indiana, Mississippi, Nebraska, South Carolina, and West Virginia. I'm not sure about Missouri. But,
Missouri just changed their law in 2014. They modified their ban.
Okay, well, thank you. So that's my best understanding. And of course, until the governor signs this bill and the law goes into effect in July, Georgia would still be on the list. I hope that's helpful.
Yeah, absolutely. We have a question for Ron, which is, does the parole legislation still provide a mechanism for the parole board to override parole once a person serves their minimum sentence? And if so, how does the legislation protect against that happening every time?
I think it needs to be first understood that the bill does not provide for automatic parole. A lot of people think that the presumptive parole bill means automatic parole, and that simply is not the case. So it's not so much a mechanism for the board to override once minimum sentence is reached. This is a mechanism for the parole board to apply the legislative statutory practices that have been in effect since 1992. I mean, basically, the basic parole process in Michigan will not change. The parole guidelines have been in effect since 92, as I was saying. And they take into consideration the prisoner's reoffending status. So the statute has always said that prisoners being considered for parole who score a low risk on their assessment guidelines should be released, and unless there's substantial compelling reason. So the standard prohibiting the parole board from granting release unless it has been a reasonable assurance that the person will not be a threat to society, it remains untouched. There has been some discussion in Michigan about trying to reestablish what's called parole appeals. And back in the late 90s, Michigan abolished any parole by the incarcerated person to appeal a parole denial of parole. So right now there is no avenue for that, but we're seeking to reinstate that avenue. So if a person scores a low risk assessment, but they're being denied parole and the parole board is not really telling them, giving them any reason for denying parole other than no interest, we want to reestablish some type of appellate mechanism in the courts to have the courts look at it to compel them to give a reason or to release them.
Great, thank you. The next question is regarding women. It says, women are the fastest growing demographic in the youth prison population and especially acutely affected by food stamp and TANF bans. So this question is, the first part of this question is directed at Drew, Elizabeth, and Nicole, so any of you can feel free to respond. It says, looking forward, do you see future possibilities in your respective states to repeal the TANF bans?
Well, I think that's a good question, and it is one that we looked at last year in deciding how to go after the food stamp ban. One of the biggest considerations is that the number of adult-only cases that we have in Georgia is extremely limited. That it's only a handful of people who are in this by virtue of not having any dependents. And so it was a very limited impact and a very heavy lift politically. In fact, it took until midnight, the final night of the session this year, to defeat welfare reform, quote-unquote, bill that would have reduced Georgia's lifetime limit for all recipients from a maximum of 48 months to 36 months, changed the sanction for a first violation from 25% loss of benefits to 100% loss of benefits, uprooted a fairly good cash diversion program that we had in place. And so unfortunately, as in the area of food stamps on TANF, the legislative mindset is very much on limiting access, denying eligibility, imposing obstacles, and punishing with sanctions, rather than looking at TANF as a tool to help people with a social safety net that is important to help people get by and find employment and secure their lives in the meantime. So it's a very toxic environment. We saw very few people being impacted. This change to the law that we secured on the felony food stamp ban would not have occurred without the governor's leadership. And quite frankly, the next focus that, at least that I've been charged with, is to look at the issue of affordable housing. Because the governor has an interest in housing as it relates to people leaving prison, people being kept in prison long after they could be released because they have no home to go to. It's a huge issue in this state, and one we're going to try and break down and focus on next, but that's my best answer.
Thank you, Elizabeth. I just wanted to add that in Alabama last year, when that state eliminated the ban altogether for food assistance, they also eliminated the ban on cash assistance. And for advocates on the phone who are interested, I can certainly connect folks to the activists who anchored that effort in Alabama. My understanding is it was a completely under the radar strategy. And but it was also an opportunity for people interested in challenging mass incarceration and addressing the stigma associated with collateral consequences to work in coordination and collaboration with anti-poverty activists. In that state, in particular, the coalition strategy focused on reentry and reducing recidivism as a part of a public safety strategy. And in previous efforts that were unsuccessful in talking about expanding the safety net or protecting the safety net, really, in conservative states dominated by fiscal hawks, that the reentry strategy was helpful in moving that policy goal forward and incorporating it into a larger, comprehensive criminal justice reform bill. So I just wanted to provide that as another example of success for these policy reforms, too.
And I'll just echo what Elizabeth said. It was very much the same calculation here on going after SNAP and food stamps rather than TANF a few years ago. Our cash assistance program is very small, and the number of adult-only households was also very small, and it was, I think you used the word, a toxic environment. It was very difficult to bring people on board to end part of the ban if we were going to try to end all of it. But it's, you know, lots and lots and lots of those collateral consequences remain for people, and working on them is really difficult, but important.
Absolutely.
Yes.
And possible. I think that just sort of before we start, I think one of the things that, you know, this conference call is sort of bringing home to me is how much we're changing around the country, and what a time of that's so ripe with possibility this is. I had an old friend who's much older than I say she had spent her entire career in criminal justice reform watching the pendulum swing away from her, and it finally feels like it's swinging back, and she's, you know, I think, sorry to be retired, but glad that those of us who are still in here are still plugging away.
That's a great point. In Georgia, as I mentioned, we have a Republican governor, 2/3 Republican control of both the House and the Senate. This has been year after year. Criminal justice reform has been a bipartisan, not just success, but a bragging point for legislators across the board. In fact, the criminal justice reform package this year, which is 85 pages long, of which lifting the food stamp ban was, you know, less than a page. So it's a small part of what was an important piece of legislation. The bill passed unanimously on both sides except for one dissenting vote. The one dissenting vote on the House side was because of the lifting of the felony food stamp ban, and in fact, on this important 85-page bill, that was the only point of discussion on the House floor. So it's but they all go home and brag about it because it is so important and it resonates across the board, and so it's very important, and we know the governor is going to keep working. I was excited to hear the talk about the mandatory minimums because that's a huge problem here in Georgia. It hasn't been tackled in significant ways. The focus has really been more on reentry, but I commend all of y'all's great work across the country. There are so many opportunities for change in this area. It's really just a question of picking the ones you can hope to move the needle on, right?
And to that point, I think figuring out where you can grab a handhold and using that opportunity to educate and bring people in is a remarkably effective way to sort of get it rolling. I've been surprised at sort of how we've kind of cobbled together sort of one thing after another over the last now 10 years, because I worked on this when I was at the ACLU as well. And with each iteration, we're able to tackle things that are harder. And, you know, this is the sentencing bill that, God willing, will pass in the next few weeks, will be the first really major sentencing reform we've had in decades. Everything that sends it in this direction.
Yeah, right.
Right. I mean, last year we were the only state that forbade concurrent sentences. So every single person who was sentenced, no matter how many counts, got consecutive sentences. Another reason we were able to overturn that 2 years ago. So, you know, this is the hard space, and you know, as we started with some easier things that were harder, that were easier for people to understand and be sympathetic toward and wrap their arms around. And as we were moving into things that are harder, more complicated, and sort of are a little more visceral for some people, it's been that process of education on these others has not at all been wasted. You know, these things that may have felt like small victories at the time ended up leveraging us into places that we could not have imagined going at the time, and made us friends in the legislature. To your point, they brag about being part of this. You know, we had a bunch of legislators show up for a prison work program that in this terrible budget time they're funding. You know, it's an amazing change in the atmosphere.
That is a great point, that year after year initiatives, incremental initiatives, not only build awareness and sensitivity among legislators, but we're also building our advocacy capacity. We're building those coalitions. We're building public awareness, all of which help support change.
And so much of what's on the other side is so dehumanizing. The opponent's language is so dehumanizing that all of these education efforts tend to reduce that. And I'll stop there.
Right.
Those are great points. I think Ron wanted to jump in and add something.
I'm listening to all this these kumbaya moments you guys have in the other states, and I'm like, wow, can we transport that to Michigan? In Michigan, we have very low-hanging fruit, and we have bipartisan support for lots of it. But in Michigan, we have a case of the tail wagging the dog. We have an attorney general that comes in at the last minute and thwarts any Republican support for it. Even though we get all this bipartisan support. Like right now, the presumptive parole bill was voted out of the House with bipartisan support. However, it stalled in the Senate in the Government Operations Committee because the attorney general has come in and said, no, we don't want to see that. He described it as a catch and release program, and a lot of misinformation out there surrounding these bills that we're trying to deal with criminal justice reform. The medical parole bill, the judicial veto bill, these are all low-hanging fruit that we can't even get traction on because we're not having the continued bipartisan support, or sustain, I should say. So I hope to talk to you guys and get some input on how you pulled that off.
Well, and it is really hard. No doubt, I hope it didn't sound too much like kumbaya. It's hard. And getting from where we started to being able to talk about sentencing was a long time.
I think that we have to take advantage of this election season to raise awareness, to raise it as an issue in campaigns so we know where the candidates stand, so we can build public support and elect people who agree with us, the very best way to make change, as we know.
Absolutely.
Thank you all for those really valuable reflections. That was a great discussion. Our next question is for Ron, and this person says, I'd like to ask Ron to talk about people sentenced for violent crimes and how their behavior can change over time.
Wow, that is a great question. And because there's this big notion in America that there's some kind of divide between violent and non-violent offenders, and that's kind of a misconception. The so-called violent offender, those are usually, once they've served a significant amount of time, is your best adjusting segment of the prison population. However, they're the most ignored segment of the prison population. Their behavior changes tremendously, and we all know that most prisoners that have served a long sentence have pretty much matured out of criminal activity. They've done a lot of self-reflection and internalizing the concepts that make them good neighbors upon their return to our society, but we don't give them an opportunity to return. So I always say, what is the definition of insanity? It's doing the same thing and expecting a different result. If we continue to release the same people we have been releasing without considering those who have the actual lowest risk of recidivism, then we're going to continue to have these high recidivism rates and high crime rates in our communities.
Thank you, Ron. The next question is for Nicole, and we can make this the last question since we're close to time here. The question says, I am a social work student in North Carolina. I have heard about Ban the Box in my state, but nothing more. I'm wondering what I can do to start the conversation, or what organizations I could become involved with locally to promote change. I am very passionate about this topic, but I feel very helpless at times because I'm just one person and I do not work for an organization yet. Where can I start?
Well, thank you for your question. There is a robust advocacy community in North Carolina that is led by formerly incarcerated leaders under the Second Chance Coalition. They actually do a lobby day every year at the Capitol, and they've been talking for several years now around challenges for employment for persons with criminal records. There are there's at least one jurisdiction in North Carolina that I'm aware of, Durham, that's the pass, ban the box locally, expanding employment opportunities for a person with criminal records for city employment in that jurisdiction. I think wherever you are, if you want to organize an effort in your local jurisdiction, if it's not Durham, there is a lot of opportunity for grassroots organizing. Even one person can get it started. And I'd be happy to be in touch with you and with anyone on the call who wants more ideas around organizing to challenge mass incarceration and also getting connected to other advocates or policy reformers in your state. And lastly, there are national organizations that seek to provide technical assistance to folks who are interested in organizing. There's All of Us or None, headquartered in California, and also the National Employment Law Project provide a range of resources. And one way to get started as a college student in North Carolina is you might start with your campus in terms of looking at what their fair chance hiring policy is for college employees, and also the application process for prospective students. Perhaps there's advocacy that you can do on campus that can help build a coalition, do public education right on your college campus around employment barriers and collateral consequences for people with criminal records.
Thank you, Nicole. And thank you to all of our presenters. That was a great Q&A. All of the webinar slides, as well as a recording of this webinar, including the Q&A, will be available online, and we'll be sending the information on how to access both of those via email to anyone who registered for the webinar. I apologize if we didn't get to your questions. The contact information for each of our panelists is on the current slide, which will also be in the deck that's sent to you. So please feel free to reach out with any additional questions. And again, a big thank you to our panelists, and thank you to everyone who participated today.
Thank you.
Thanks very much.
Thanks for having us.
Thanks, everyone.
Bye.